Module 7. Overview of Intellectual Property Law. Introduction to Intellectual Property. Now that you have achieved a thorough understanding of the fundamentals of academic integrity and acquired the skills to avoid inadvertent plagiarism, it is important to look at not only ethical but also legal principles that guide us when using creative works. Intellectual property is a broad term for a right that can be protected by law, covering intangible property that may include copyrightable works, patents, and trademarks. There are distinct laws that apply to different types of works and different types of use. So it is important to begin to have an understanding of this complex system that offers legal recourse if a person or organization is using their original works without proper permission or compensation. Intellectual property laws also apply to works of authorship on the Internet. But frequently these laws are disregarded because it is so easily viewed, shared, downloaded, and copied. Let's look at the major category of copyright first. Copyright. Copyright is a type of protection for original works of authorship fixed in a tangible medium of expression and is based in the United States Constitution. When hearing the word copyright, many think first of works such as books, art, music, and photographs. But this protection also covers designs, computer software, architecture, drawings, and choreographic works, for example. Students' original work of any kind, including writings, software code, and artistic creations, are equally protected by copyright law. Therefore, as a student, you own all the rights to the works you have produced throughout your educational experience. Copyright extends to published and unpublished work. It does not cover facts, ideas, systems, or methods of operation, but could extend to the way in which these are expressed. You do not have to register for copyright for it to be in effect. It comes into existence when a work is created. The United States Copyright Office defines copyright as a form of protection provided by the laws of the United States to the authors of original works of authorship, including literary, dramatic, musical, artistic, and certain other intellectual works. This protection is available to both published and unpublished works. Section 106 of the 1976 Copyright Act generally gives the owner of copyright the exclusive right to do and to authorize others to do the following: reproduce the work in copies or phonorecords, prepare derivative works based upon the work, distribute copies or phonorecords of the work to the public by sale or other transfer of ownership, or by rental, lease, or lending. Perform the work publicly in the case of literary, musical, dramatic, and choreographic works, pantomimes, and motion pictures and other audio-visual works. Perform the work publicly in the case of sound recordings by means of a digital audio transmission. Therefore, it is a breach of copyright law if anyone other than the original creator uses works in one of the ways we just described without proper authorization. So the next time you're searching the web for a cool image to go nicely with your personal blog post, be sure to limit your search to images that fall under the category of public domain only. Yes, even if you cite the source of a copyright-protected image, you are still in violation of copyright law unless you obtain permission from the owner of that image to use it on your blog. Patents and trademarks. Inventions and discoveries are covered by patent, not copyright law, but the way inventions and discoveries are expressed might be. A trademark is often associated with a particular brand or company, as it is the form of protection for words, phrases, symbols, or designs, distinguishing the origin of goods and services of one person or company from those of another. For example, Both the swoosh logo and the Just Do It slogan are trademarks of the Nike company. Patents and trademarks must be applied for and registered to be in effect. Fair use. Fair use is one exception to copyright protection, and it allows some limited uses of works without the author's or owner's permission. Courts could determine use to be fair depending on the circumstances under which parts works are copied, which include criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, or research. Each time you quote from a book or news article in an essay or research paper, for example, you are indeed taking advantage of this statutory exemption. According to the Library of Congress website, fair use is decided by courts based on these criteria: the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. Is it long or short in length? That is, are you copying the entire work, as you might with an image, or just part as you might with a long novel? The effect of the use upon the potential market for or value of the copyrighted work. Limited and appropriate use is key to understanding fair use. A professor photocopying 10 copies of one chapter of a poetry anthology for a class she is teaching might be considered a case of fair use, since it's copying only a small part of a work, and for a non-commercial, educational purpose. However, if the professor repeatedly uses this chapter for more sections of a class and for more semesters, it becomes less likely to be deemed a case of fair use, and permission from the copyright owner should be requested. Public domain. In everyday English, a domain means a territory under rule, or an area of activity or knowledge. In the context of copyright law, an original work is said to be in the public domain if it did not succeed in fulfilling requirements for copyright protection, or its protection has expired. These works can be used in any way, without permission from the author or owner. Works created before copyright law, such as those of Shakespeare and Bach, are in the public domain. Cases involving works recently created can often be controversial and involve lengthy trials. Appropriation. Cases of appropriation in the realm of art have raised controversies regarding copyright. Here, appropriation means the use of objects or images that already exist in a new work of art, with little or no transformation at all, as in Marcel Duchamp's Fountain, or Andy Warhol's Campbell's soup cans. This could mean reprocess, adopt, imitate, recycle, or mimic a work in its full form. The new work is not in violation of intellectual property laws, so long as it is judged to recontextualize the object or image. However, the line between appropriation and misappropriation is not always clear. One of the most influential leaders of the pop art movement, Andy Warhol, encountered lawsuits throughout his career raising questions of misappropriation. Back in 1964 in New York City, Warhol created silkscreen copies of photographer Patricia Caulfield's Image of Flowers to cover the walls of a gallery. Caulfield spotted the work in a bookshop by chance and asserted her authorship and right to the photographic image of the flowers. In court, Warhol was deemed the author of the silkscreens, but was forced to pay financial reparations to the photographer in recognition of copyright. In the case of Campbell's soup cans by Warhol, however, it is considered an appropriated image and not in violation of trademark law, because people were unlikely to see the painting as promoted by Campbell's or another company. Conclusion. Copyright laws are very complex in nature and are generally handled by specialized legal professionals who devote their careers to this area of law to ensure works of authorship are protected. This is merely an introduction to the field of intellectual property, with its myriad nuances, guidelines, and regulations. While it's highly unlikely that a student will be accused of copyright infringement in the context of scholarly work, there were cases where students were sued by music and film companies for sharing and distributing copyrighted materials on campus. In our next and final module, you will acquire practical scholarly research tools and strategies to help you stay organized and remain in control of your school workload.